Good afternoon, this is Sean Golden with Golden & Golden, here to discuss the basics of what is reckless disregard when talking about the infamous FBAR penalty, right? FBAR, foreign bank and financial account reporting. If you're a U.S. person, if you've got foreign accounts, you didn't report the foreign accounts, you could be subject to a penalty. U.S. person generally means U.S. citizen, legal permanent resident, foreign national who meets the substantial presence test, excuse me. So generally, FBAR penalties come from you missed the filing, right, and then you filed it late. You don't have to file for an extension currently for the FBAR. It's on automatic extension until October. Maybe you never filed it late, filed it incorrectly. You got a soft letter from the IRS, and then the IRS decides to ding you based on the inaccuracies in your FBAR. But generally, it's from not filing it. Penalties can be civil or criminal. Most of the time they're civil. It's pretty rare for criminal penalties. Those normally stem from an additional issue, money laundering, structuring, smurfing, tax evasion, things like that. The reason why the reckless disregard is so important is because reckless disregard is a lower standard of willfulness, but the IRS will still hit you with the full penalty, right? That's the way they work. Willful penalties are tough. 50% maximum value of the account during the year, or $100,000 adjusted for inflation, whatever's higher, essentially making $100,000 the floor. That is the maximum penalty, but you'll be hard pressed to find an agent who's not going to issue you the maximum penalty to start. There's some discretion, right? Agents, examiners, they have discretion to reduce the penalty, but once that penalty's been issued, it's pretty tough. That's why amnesty is normally a good option. We'll discuss that in a minute, but let's focus for a minute on reckless disregard. It can get very confusing when it's willful versus non-willful. Aside from the difference in penalty, the definition, it's not a bright line test. It's not like you go, okay, here's element A, and here's element B, and here's element C, and it all nicely fits in this little box. You could decide whether you're willful or non-willful. It's basically a totality of the circumstance test, which means you just throw everything in the pot, you look at it, and see, hey, was I willful or non-willful? You could imagine how reasonable minds will disagree as to what's considered willful, what's considered non-willful. The main problem is that sort of gray area. Are you a heightened form of non-willful but still non-willful? Are you a lower form of willful and therefore willful? Reckless disregard is one example. With reckless disregard, there's no intent. And so this brings me to another point. When you're dealing in the civil arena for FBAR penalties, they don't have to show intent to show that you're willful. Stupidity, right? So essentially, they don't have to show, hey, Michelle intended on not filing the FBAR. She's willful. It could be she acted with reckless disregard. What's considered reckless disregard? Well, one recent example was in a case called Kimball. And what the IRS what the court said essentially was that not filing the Schedule B, putting no on there actually, not the not filing, putting no is reckless disregard. Now, just messing up Schedule B in and of itself is not per se reckless disregard, okay? It's the totality of the circumstances I spoke about. So in that case, for example, they had Swiss bank accounts, they were numbered accounts, they were at UBS, which is a bad bank. She was already found willful underlying. Icing on the cake was that she'd put no on Schedule B. So in that sort of situation, you look at the totality of the circumstances and shoulda, woulda, coulda known, right? That's why you have to be a bit careful if you have facts that may put you in a situation where you may look teetering between willful and non-willful. It's important to determine, speak with some specialists, board certified, who do tax, only, specialize exclusively in this kind of area. So you can walk through the path, get an idea of what the IRS may say, what they may not say, what they may believe, and what they may not. If you haven't been dinged yet, you may consider entering one of the offshore voluntary disclosure programs. They're called tax amnesty programs. Voluntary disclosure. There's a couple of different programs. If you are willful, there's really only one opportunity for you, and that's the voluntary disclosure program. That's VDP. It used to also be OVDP, which was only for offshore, but they closed that program in 2018, expanded the traditional version of the program. which is VDP. For offshore or domestic, if you're non-willful, you have lots of options available: streamlined domestic, streamlined foreign, reasonable cause, and delinquency procedures. Although they did recently update the delinquency procedures, so it's basically just a reasonable cause statement. We have lots of free information available on our websites. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.